Hello all. Am I audible now?
Yes, ma'am.
Yes.
Yeah, I think video is not coming. There's some problem with my system. Just a minute. Please cooperate with it. Uh, Otherwise, let's continue without camera. Some technical issues happened today, so just cooperate. I think the presentation is also having some problem. Meanwhile, if you want to utilize this time, you can ask me questions if you have any queries from our previous classes. Okay. Yeah. So we have discussed about doctrine of privity of contract in our last class. So anybody has query on that?
The video has not been uploaded in Initio.
Yes, yes. So the ab initio team is already working upon that. So it will be uploaded soon.
Okay.
Yes. Meanwhile, but if you have any kind of queries in our previous classes and you are no following all the things which we are discussing here, then you can also shoot all the any doubt which you have. It is quite confusing, so I hope you all are on same page. When suppose if this question is coming, so you have to know mention what exactly the privity of contract is, what are its exceptions, stranger to what is stranger to a contract and stranger to a consideration concept, and the illustration which we have discussed. Prakriti, it will be in ab initio platform, so you can subscribe that. There you will get the videos and the case laws and the conclusion which we have reached. Okay. So today we are will be discussing a new topic. Uh, Wait a minute. I think yes. Before the breach of contract, we will discuss about the performance of contract. So, what do you mean by actual performance of contract? When both the party, promisor and promisee, they both perform their part, that is actual performance of contract. So suppose if you go to a vegetable shop and you buy a vegetable, and the vegetable vendor has given you a vegetable and you have paid the price, that is actual performance of contract, and it is also called as a discharge of contract. And one more thing, when such things will happen like immediate, but like you are the promisor is performing the performing his part and the promisee is performing his or her part, that is called spot transaction. Okay. Second is your attempted performance. So there is always two type of performance: actual performance and the attempted performance. In this, the one party who wants to perform, but the suppose the promiser is trying to perform his part, but the promisee is not allowing it to perform. In that case, what will happen? Say I give you example. You want to build your house, and you have asked certain people, certain laborers to come and start the manual work, like foundational work for the purpose of construction of your building. Okay, now the laborers already came on the time which you have mentioned them to come with all their tools, and they are sitting to do their work, but you have not opened the gate. Now you are restricting them to enter the space wherein they have to perform the work. They came with all their tools, they are willing to perform, right? But you are not allowing. In this case, who is into default? You. So do you think the laborers will not ask you money for that? Will.
Yes, ma'am. They are entitled for the money.
Yes, because they offered you service, but you have restricted them, so you have defaulted your part. That doesn't mean that they have defaulted their part. So the obligation for paying them is there, right? And their right, the laborer's right to receive the payment is there. But the laborers are now not obligated to give the service to you on another day. So their obligation has been done. They are not obliged you to perform the same work again for the same amount which they have recovered from you. You will not say that, "Okay, okay, I am paying you right now, but now this the service which you have not rendered it today, you have to render it tomorrow." This will not happen. That will be another work. Okay, so for the like, if you were seeing in the lens of laborers, their obligation is not there, but rights will be there to recover the money. Okay, now those attempts, the laborers which are they are doing, that should be unconditional. They will not give there any conditions. They have to come on that same time. They have to come at the same location where you have already asked them to come. So they have to come at the proper they have to come that at proper time, at proper place, with all proper tools which they are required to in order to perform the service. Or they have all the tools with them, and those are laborers, not any other. Not suppose an engineer is coming for the performance of no construction. So the person who has the same professional capability to do that work, that person has to come, not something else. Okay, and now the third point is by able and willing person. What do you mean by able and willing person? You have to relate it with the specific relief act concept. आप लोगों ने स्पेसिफिक रिलीफ एक्ट पढ़ लिया है? So by able and willing person, if you can relate with specific relief act, section 14. Sorry, it is not section 14, I think. The person is ready and willing. What do you mean by that? Anyone?
The person is going to do his contractual obligations from his side.
Okay. He is able and willing, not he has done it. He is willing to do his. If you go to section 16 of specific relief act, let me show just a minute. Today I have some problem with my system. Okay, if you see the point numbers 16, section 6, 16 C. So here it is written, it's that he has performed or has already been ready and willing to perform the essential terms of the contract which are to be performed by him, other than the terms the performance of which has been prevented or waived by the defendant. Okay, so in first initial we are reading that okay, the other person is not preventing him to perform that, but the second point is your he's ready and willing to perform. So suppose that in case of say purchase of immovable property, so you want to purchase the immovable property and the other person has to sell the immovable property, right? So if you are not having the money, you cannot say tell that other person no to transfer that immovable property in your name, correct? If you're not paying that amount to him, will he transfer the immovable property to you?
No, ma'am.
And you are saying that ki, okay, I am ready and willing to perform my part, but you are not selling me. So if you are saying that I am ready and willing, you have to prove to the court that okay, I have this much of amount and I am willing to give that amount. Either you can no uh, deposit that much of amount to the bank, to the court, or you can show that ki, okay, I have this much of amount, it is not required to deposit the entire amount. There are numerous cases with regard to this. It is very very important point when you have to prove that you are ready and willing to perform the part. Suppose if you don't have the money in your bank account, all of your bank account is having no is having only the minimum balance, then and you are saying to the no, vendor that "Ki, I am ready and willing to perform my part," he is not transferring the property. Will the court will no agree with you? No. You need to have you need to prove that before no discharging yourself from the obligation. You need to prove that you are ready and willing to perform by sufficient means, wherein suppose in this case there is the payment of money. Suppose in another example, the laborers, they have to do certain job wherein the uh, they need to have hands, but if they have some kind of trouble with the physical incapacity with their hands, will they be considered as ready and willing to perform that performance? No, right? So whatever the tools or whatever the requirement they need to have with them, that has to be there, then only it will amount as ready and willing to perform. Is it clear? Now the last point is seller should give sufficient time for inspection of good. So suppose if you went to a vegetable vendor to buy vegetable, but he is not allowing you to see that part, see the vegetables or sufficient time for inspection of that vegetables, then you will not required to pay that amount to him. So it is not only that the delivery has to be done, that before the delivery he has to allow for a sufficient inspection of that work or that good. If it is a service, then it has to be work, it has to be no that service which suppose if any kind of drafting of agreement is there, then he has to give a sufficient time to review that draft which you have prepared. Then only you are allowed, then only your obligation will come up, wherein you have to pay the price to the provider.
Ma'am, is that the principle of caveat emptor you're talking about?
No, that is a different thing. So let's the buyer be aware that if your the soga thing is sales of good act, that is different thing. Okay, here we are
Yes, ma'am.
here we are talking about the discharge. And the discharge of contract when happen, when you perform the contract, right? And this performance may be either actual performance or it might be an attempted performance. But when you are saying that ki, I tendered to perform and now you have to pay the money, then you have to prove that ki you have satisfied all the conditions for that attempt. Like your attempt should be not conditional, it should be unconditional. You are saying that ki, okay, I will come to perform the service only when it will rain, otherwise I will not come. And if doesn't rain, then you are no required to pay the price, because today it doesn't rain and I will only come when it rains. So my part is done. You cannot put like any kind of conditions.
Ma'am, what is the difference between sufficient time and reasonable time?
Okay, so that we will discuss with regard to you are saying about the at proper time, place, proper quantity, there you are asking for reasonable time or proper time.
Here it is mentioned seller should give sufficient time. So, is it sufficient time or it should be reasonable time?
See, sufficient time, reasonable time, these are all subjective word. Okay, so what is sufficient and what is reasonable? You can say that it is a sufficient or a reasonable time. You can say sufficient or reasonable. It is like it depends upon the facts and circumstances. So for certain goods it might be 5 minutes would be sufficient or reasonable, but for certain things, like suppose if you are you have some kind of missile or some kind of nuclear stuff, there the reasonable time or sufficient time would be longer compared to what if you are buying a vegetable, right? So
Ma'am, in the provision of gift in Transfer of Property Act, here there is a mention that the donee should accept the gift within the lifetime. Within the lifetime, he or she should accept the gift. Right? Here it is mentioned in section 122 of the Transfer of Property Act. Right?
Mhm.
Yes. Ma'am, is according to Indian Contract Act, there should be a reasonable time on which the particular acceptor should be accept their contract. So, is it the reasonable timeline? Is it mentioned under the gift?
See, gift is a special kind of contract. Okay, so gift is dealt under the TPA. In gift is only one wherein, see, when we are saying about the contract, there should be a three essential elements should be there. Sorry, agreement has to be there. And agreement means three thing: offer, acceptance, and consideration. Do you think in the gift there is a consideration?
No,
Ma'am,
ma'am.
no.
Right. So when we are dealing with a special kind of contract, but it is a contract, right? Do you agree or not?
Yes, ma'am.
Okay, so when we are, but it has to be dealt under the TPA Act. So what TPA Act is saying, what are the whatever the things has to be mentioned in the TPA Act, that has to be complied in order to be a valid gift. The same principle will not apply in whatever we are studying in the Contract Act.
Ma'am, why it is then say that the Transfer of Property Act is a supplementary act to Indian Contract Act?
Transfer of property is supplementary. What do you mean by supplementary? First of all, you need to understand that.
Ma'am, supplementary means it is in addition to Indian Contract Act.
Yes, it is enhancing something,
Yes, ma'am.
right? So it has, like when I'm saying about your Insurance Act, it is also supplementary, because when insurance is also one contract, but in the contract we are saying that ki oral or a written, both can be a contract, right? In both mode. But in Insurance Act, insurance has to be in a written mode. Similarly, for the for the gift, it is like without consideration, it has to be without consideration, it has to be it is considered as a contract, right? But the other terms and conditions, like one is your offer, acceptance, and acceptance can be during the lifetime. But if the acceptance is not there, then that is not a gift. It has to be acceptance.
Ma'am, my question is simply that here the timeline is given is a broader aspect that donors should be accept the gift during their lifetime. Then it is considered as a sufficient time to sufficient time or reasonable time to accept the gift. You are saying that sufficient and reasonable time. I think both are not same.
Okay, where it is written in the case laws? You have to come up with that. Okay. When
Okay,
we are
ma'am.
discussing the law, it should be either in the law, and it is the interpretation of the law which comes from, which is from the judiciary, right? There the reasonable, there the it is the law has been given that it is should be during the lifetime of the donee,
Okay, ma'am.
right? But when we are saying here in the contract act, wherever we have mentioned that reasonable person, reasonable time, this reasonable has to be decided by whom? Who will
By the
decide this?
court. By the court.
Exactly, exactly. But there it has been specifically mentioned that okay, this is the timeline. Now if you go into the specific relief act, okay, in the specific relief act is also dealing with the contracts,
Yes, ma'am.
right? So in that case, where when we have seen that substituted performance, so in this case when the substituted performance can be done only when, how much period
Ma'am,
of
when
notice, let me complete, how much period of notice is required to be given before the substituted performance?
ma'am, I'm not aware about the how much period required for notice.
See, there it is mentioned that 30 days of notice period, like before going for a substituted performance, the minimum timeline is 30 days. Okay, so that 30 days might not be reasonable for any other contract, might be reasonable for any other contract. So but there they have given 30 days or more, but they have not specified a lesser period of time. So this reasonability is always no change with respect to fact and circumstances. But if the law is saying certain timeline, then you have to obey that. Like in case of specific relief act, there it has mentioned that not lesser than 30 days is not given an option. You have to give a minimum 30 days, even if that required a lesser period of time. That might not sound as a reasonable to you, correct? But when there is a reasonable word is mentioned or sufficient time is mentioned, then it is depending upon the facts and circumstances, and then we have to refer the judicial interpretations.
Ma'am, in any case of emergency, can we give when substituted performance less than 30 days notice?
So there it is not mentioned, so we have to give a 30 days only. But now that will be again that's how the law is, right? There it is not mentioned that in case of emergency you can give a lesser than 30 days of notice. If suppose if between two parties you can change the terms of contract. So if the other party has given, because what is that, ki 30 days if you have given, then you have certain right. If you have no 30 days of like 30 days of notice period you have given, then you have right for, what if you are not give the 30 days timeline, and what if you give the 30 days timeline, what right you will extra get? Compensation, right? The expenses and the cost. So if you are into in such an emergency situation, you will not have that right. But if the other party has agreed, then he might, then you can recover that amount. So then it becomes a mutual part. However, the law states 30 days. So So if you will not give a 30 days period of notice, then you will not able to or not entitled to recover that amount which you have incurred. Correct?
But ma'am, in case of perishable goods, if 30 days will be like much enough, then in that case, what can be done?
That's how the law is. So you need to see where the substituted performance things will come up. So the specific relief act deal with certain other like not with all the things. So you have to see the perishable goods are coming. Then it's when we are dealing with the goods, then it's a SOGA, Sales of Good Act,
Yes.
right? So you have to see where which law will apply. So when we are talking about immovable property, then Transfer of Property Act will come. Okay. So shall I continue?
Yes, ma'am.
Yeah. Who will perform? So it is either to be performed by the promisor himself. So if you are saying that ki, okay, no, if you are saying that ki, okay, I will file your ITR return. So you being a chartered accountant, that has to be performed by yourself. You cannot say to any other person who is not to an engineer to perform the task, right? So if it is something which is to be of your personal qualification in nature, then it has to be done by yourself. But suppose if something is there wherein it can be performed by anybody else like your agent, then it can be performed by the agent also, not necessarily to be the promisor himself. So it depends upon, suppose if the teaching, so teaching has to be done, if you are if you want to study from, if the teaching has to be done from me, it has to be done from me, not by the peon or by anybody else who is not dealing with that qualification or that requirement to be to have for the purpose of teaching. Correct? So it has to be performed by promisor himself if it is a personal nature task. But there are many other tasks also, like wherein no, it can be performed by any other person, like by agent, or if the promisor has died, then it can be also done by the legal heir. Say you have taken a money from the person and now you have to return that amount to that person. So if the promisor has died, then in that case his legal heir can pay that amount. But if the promisor has no taken a task of any say any art or painting has to be done by him, but he died, after that the legal heir cannot do that, so then it becomes void. However, if the legal hire has also no, willing to give that painting by himself and you have accepted that work, then it is a valid transaction. Third person. So if you have, this is third person means the substituted performance only. So if you have taken the substitution of that task by somebody else, then the promisor is not required to perform now. You will not ask for the specific performance when you have substituted the performance from somebody else. Joint promisor. So anybody has idea about the joint promisor? What exactly it is mean? What it means? Say if I say that Mr. A has promised to build a building uh, to Mr. B. ओके एंड मिस्टर ए जो है वो खुद से अकेले नहीं करने वाला है ये बिल्डिंग का कंस्ट्रक्शन. मिस्टर ए विल डू विथ एक्स वाई जेड. देन हियर मिस्टर ए एक्स वाई जेड आर ऑल टुगेदर जॉइंट प्रोमिसर एंड वो किनके लिए बिल्डिंग बनाने वाले हैं? बी के लिए बनाने वाले हैं, राइट? अब इसी केस में अगर वो बिल्डिंग बनाने वाले होते बी एंड सी के लिए, तो बी एंड सी बिकम अ जॉइंट प्रोमिसी. and agar B and C together they decided ki okay, this building is to be constructed for them and they are willing, they have to pay 1 lakh rupees, then here both B and C together has to pay A, X, Y and Z that entire amount of 1 lakh rupees. Okay, so let's discuss about the promisor. So when uh, when in case where is jointly or 3 or 4 parties together agree to perform certain work, then in that case they all are jointly and severally liable for that performance. So what do you mean by jointly and severally? Because that means all of them together has to perform that, or either one has to perform that. आपने पहले ये कॉन्सेप्ट पढ़ा है? Okay, so I consider that nobody has awareness about this. Okay, so if I say that joint promisor here, it means when jointly and severally, it means like, say, if I give you another example wherein 5% together has decided A, B, C, D, E. All 5 has decided to perform certain task for Mr. A. Okay, so now the Mr. A, instead of reaching to all 5, he reached only to Mr. A. Then in that case, A has to perform that task for the promisee. In case of suppose he all 5 has taken loan from bank. Okay, all 5 has together taken a loan from a bank, and together they all has to pay that amount to a bank, or either one has paid the entire amount to a bank, all it will discharge the performance. Is it clear or it is confusing? Kishan, suppose if I give you an example, suppose Kishan has taken a loan from Anusia. Okay, so Kishan has taken a loan. In that case, Kishan has to pay that amount to Anusia. Suppose instead of Kishan, it's not only Kishan, but say all other 5 member here, Priyanshu, Ananya, Soumya, and SK, all 5 has taken loan from Anusia. So Anusia has no right either to recover it from Kishan or from all the 5 of you. So suppose Anusia and no, Kishan are good friend, and Anusia has discharged Kishan from paying that amount. So say Anusia, the loan amount is 1 lakh. So Anusia has discharged Kishan from paying his part. Now Priyanshu, Ananya, Soumya, and SK has to pay their amount, or whether they have to they have paid their amount 20,000, 80,000 they have paid to Anusia. So what about Kishan? Kishan is discharged to pay that his amount to Priyanshu, Ananya, Soumya, and SK, or he is not? When we are saying that joint liability, that means Kishan is still liable to pay Priyanshu, Ananya, and Soumya, and SK. So his 20,000 has to be divided between all the 4, and the other 4, all the 4 can recover that amount from Kishan, but Anusia is not required to recover that.
And that is subrogation.
Subrogation is the different thing. Subrogation you have read in insurance, right, or any other place?
In Indian Contract Act.
Okay, so what do you mean by subrogation?
Ma'am, suppose
what your understanding?
Ma'am, once surety pay the amount to the creditor, once surety pay the in the default of principal debtor, surety pay the amount to the creditor, then surety reserve all the right to collect the amount from the principal debtor. That is the subrogation, ma'am.
Yes, so he will be in the shoes of that person, right?
Yes.
When so that we will be discussing when we are doing this uh, concept. Okay, so it means what? Ki suppose instead of the creditor is recovering, the surety is recovering that amount from the other person, so he will be placed in the shoes of creditor. But in this concept, it is not like that. It is not similar to subrogation.
Ma'am, like co-surety, ma'am? Can we get the liability of co-surety then?
Yes, you will say that the co-sureties will be, the concept will be similar to that. Because if one person has paid that amount, the co-sureties are still can recover that. It is similar to that. So
Okay, ma'am.
here from Kishan, Priyansu, Ananya, Soumya, and SK can recover that amount. That is called effect of release of one joint promisor. So Anusuya has discharged Kishan, but not all other people. He is still liable to contribute his portion to the other person, because all of them are together liable for that amount. So if she has discharged 20,000, that means all of you are now responsible to pay only 8,000, 80,000. So now the other four, so when you four have paid it, so that 80,000 is the liability of all the five, not only four. I hope it is clear.
Yes, ma'am.
Okay. Devolution of joint liabilities. So suppose if that one party died, in that case, that party's legal representative will come into that source, and he will be liable for payment. Okay, so suppose all the promisor died, then in that case, all the promisor's legal representative will be responsible. So the liability will be no will go down to the legal representative, and all the legal representative has to pay that amount. Any one of joint promisor may be compelled to perform, then he can call for contribution for the others from others. So it is like, suppose if Kishan is only in for no pushed to pay entire amount to Anusuya, then in that case he can recover the amount from the other sayers, like 80,000 from Sachin, Ananya, Soumya, and SK. Okay. Sharing of loss by default in contribution. So if Kisan become no insolvent, in that case he's discharged from the liability. In that case, the other people has to bear that loss. So 1 lakh has to be paid by Sachin, Ananya, Soumya, and SK. These are the four situations which I have discussed. I hope all the four situation is clear.
Yes, ma'am.
Yes, ma'am.
Yes, Ananya. Okay. So discharge of performance. When we are saying about discharge, means that what do you mean by discharge?
He has no incurred no liability, ma'am. Right now, he has incurred no liability. Perform the contract.
Yes. So it is like both of them has performed their contract, or the contract, there is no other the contract comes to an end, right? It contract comes to an end by actual or attempted performance, this by mutual agreement. So mutual agreement is like novation, alteration, any kind of no if suppose if in case of mutual agreement like novation, alteration, remission, rescission, that time also the contract is discharged. So novation means there is a change in parties. If there is a change in parties, like instead of Kishan, he said that ki, okay, no, I am not willing to pay, I will not be there the party in the contract, I will put say XYZ in my place. In that case it is a novation, because party has been changed. Okay, so the earlier contract has been discharged and the new contract came into place. Alteration. So suppose Anusuya has said that instead of 1 lakh, now all of you has to pay 80,000 rupees. So now the terms and condition has been changed. In that case, it is again the earlier contract has been discharged and the new contract came into place. Remission. So if say it is the same in case of it is alteration, you can say that okay, it is not necessary with regard to amount. It may be with regard to terms and condition also, like any other terms and condition, like instead of paying on 25th you can pay on no 30th of this month, then also it will be an alteration. But remission is always with regard to amount. So when she is reducing the amount, then it will be remission. Rescission. So when the contract is cancelled after the offer and acceptance is done, then it is rescission. We have discussed about when the revocation is done and when the rescission is when the rescission is happening. Okay. Impossibility of performance. So the contract is also discharged when it is impossible to perform. So impossibility may be at the time of making the contract also, like both of you are not aware about this impossibility and you have entered into that contract, then also that contract cannot be performed later on also because it is impossible to perform. So impossibility may be ab initio, which make it void. Okay, so that time when the impossibility happened after the contract formed, then what we will call it void contract. Like at the time of making the contract it is valid, but the impossibility happened after you form the contract, then it becomes, due to the supervening impossibility, the contract become void. Okay, so
Ma'am,
such.
ma'am, I have a doubt with the subsequent voidability. And
Yes, please tell me.
ma'am, right, in certain circumstances, unforeseen changing in law, the contract is void, as you say. So, so what is the difference between these circumstances and subsequent voidability?
Sorry, I'm not able to hear it. Can you repeat?
Ma'am, after changing in law,
Hmm.
suppose contract is valid at the first instance, contract is valid.
Hmm.
After that, there is a changing in law, so that it is impossible to perform the contract. Now it is void, right?
Yes.
So I think it is subsequent voidability. No, it is not subsequent voidability. Right. Ma'am, I got it.
So at the time of forming the contract it is completely valid. So if you say that no you have suppose it right now your cryptocurrency transaction in one of the suppose in the China it is the cryptocurrency transaction is valid, say, right? It is a legal thing, but later on when it becomes, now it is illegal. So before it is illegal, it was a valid transaction, so you will say that it is a valid contract, but the moment it become it is banned by the China, then it becomes void contract, because initially it has the valid status. That's why we say that void contract, but we are not saying as void agreement, because in case of void agreement it is from the beginning it is void. It cannot come in it has no essential element of contract. So if any of the essential element is missing, it will not become a contract. So enforceability is not there. So that's why we are saying void agreement. But the moment when we are saying about void contract, initially it is valid, but because of certain thing, it become void. So we call it as a void contract. Okay, one of thing is your unforeseen change in law, destruction of subject matter essential to the performance. So suppose there is two person who agreed to marry in case of suppose a Muslim, they both agreed to marry, but one of the person at the time of saying no offer and acceptance has to be done, but if at the time of acceptance has to be made, that time itself the person died, then the marriage cannot be possible. So uh, it is again discharged. Non-existence or non-occurrence of particular state of thing, So if you have if you have given a particular state of thing to be there, but that is not occurring or not existing, that time also the performance is considered as discharged. The declaration of a war. So you have during the time when there is a before the war, say between India and China, there are a lot of transaction happening for a purchase and sales of toys. But when the war has been declared, then any of such transaction is not possible, right? So if some person has already entered into a contract and the other person has already no done his part, then the first person is not required to perform his part. So suppose the China has already transferred the good, and now you have to pay that amount. You are not required to pay that amount. You are discharged because of declaration of a war. Discharged by lapse of time. So, in Limitation Act, you have read about that there is a limitation period of 3 years. So, you have taken a loan from a person and you have to return it. But if you have not returned it for 3 years, then and the other person who has given you a loan amount has not asked for that amount also, then he has lost the remedy to recover that amount from you. So, it will be considered as discharged by lapse of time. Okay. Discharged by operation of law, like in case of death or insolvency. So suppose a person whom you have given certain kind of suppose if you have given a gold ring to a person, and now and the another day the person has said that ki another day you come and I will pay you that amount to you, but he died and he has not enough estate with him to recover that amount, then you will not able to recover the residual amount from him or his legal hire. Okay. Similarly, in case of insolvency, so if the person is insolvent whom you have lent the amount, then you cannot able to recover that amount. Promisee may waive performance. So if you have given a gold ring to him and you have waived your right to recover that the sale value of ring, then in that case the other person is also not required to pay and he is discharged by his part of performance. Merger of rights. So say the promisor and promisee both married, you have all right to recover that amount from him or you might not recover the amount. It will be considered as in a waiver. But if I say that no, I'll give you another example. Suppose in case of merger of right, like earlier you were a tenant of the property and now you become a owner. So now since you now owning the land or owning the property, now you're not required to pay the tenancy amount to anybody because you are the owner of the property. Now you have there is a merger of right. So the supreme right is ownership. So you now cannot be say that ki I am a tenant also. Next is your effect of neglect of promisee to afford reasonable facilities. This we have discussed. Discharge by breach of contract. So if one party is not no performing his part, then it will be considered as breach of contract. So you have no you if you have given a property sorry, if you have sold a ring to the other person and the other person is not paying you the amount, then it is considered as a breach of contract. So you have other right. Similarly, if I will reverse the scenario, that the other person has to pay the amount and you have to give the gold ring. If the other person has not paid the amount, then you are not required to perform your part. That is, you are not required to now give the gold ring to the other to the first person. In this case, you are discharged from your part of performance. So it is written like that: if one of the parties to a contract breaks the promise the party injured thereby has not only a right of action for damages, but he is also discharged for performing his part of the contract. So the remedial action will be there. Okay. So what do you mean by damage and damages?
Ma'am, damages means compensation, and
Hmm.
damage is actual damage what he occurred the loss.
Okay, correct. So breach can be actual or attempted, anticipated.
Yes, ma'am.
So there is two type of breach: anticipatory breach and actual breach. In case of actual breach, you have the liability, you have the right to claim the damages immediately. But in case of anticipatory breach, you might wait for, uh, like, you either terminate it immediately, or you may wait for that date when the actual termination will, when the actual breach will happen. So why you will wait for that actual breach? Because you might think that the other party may perform it or may not perform it. There might be a situation. So if you are giving a chance that, okay, let's wait for that person, that on the date, actual date, whether there might be a chances that he will perform it, then you can go for anticipatory breach also. So there might be a situation when, in case of anticipatory breach, that if you have waited for that date, say 26th, today's 14th, you have an idea that okay, that person is not going to, he has already let you know that there are high chances that I will not able to perform that duty. No. So it is a case of anticipatory breach. So now you are saying, okay, I will wait on 26, whether that you will perform it, if you will able to perform, then perform, or if you will not, then obviously then the actual breach will come. But during the period of this 14th and 26th, if certain things happen which make the party impossible to perform that duty, then it is considered as supervening impossibility, and that other party is not required to pay you damages because of impossibility. So there might be three situations happen. One is your when you can claim damages when actual performance might happen, and the third is your supervening impossibility. So in the anticipatory breach, these three options can be there, but in case of actual breach, the actual in case of actual breach, you have only a right of damages. Now, remedies for breach of contract. So these are the remedies: suit for damages, rescission of contract, suit for specific performance, suit for injunction, suit upon quantum merit. As we discussed about damages, there are many type of damages. One is your ordinary damage, another is your special damage. What do you mean by ordinary damage?
Ma'am, loss is like ordinary, like nominal loss.
No. So nominal is different thing. So there are there are many kind of damages. Let me change it the slide. Okay, so we have ordinary damages, special damages, vindictive damages, nominal damages, prefix damages. When we are saying nominal damages, that means court is saying that okay, there is a damage happened, but in order to no in order to no say that in the decree that okay, they are agreeing upon the damages, but they are agreeing about the damage, but they are no but a small amount has been, a nominal amount has been given to the person who has incurred the damage. So then it is called as nominal damages. You are not given actual amount of the loss which you have incurred. Okay. But in case of ordinary damages, what happened, that the actual loss, so say suppose you have given a contract to buy a rice today. On 14th, you have given a contract to Mr. A that I want to buy a rice, buy 1 kg of rice from you, which has to be sold on 26th. So you delivered it on 25th. Okay. And the price is 100 rupees, say. So you have given an order for 100 rupees, and on 26th it has to be sold to some to Kisan. So say at the price 150. So in this scenario, on 25th, if you have not received the rice of 1 kg, you will not able to deliver the same on 26th on no, at rupees 150 to Kishan. That means here the damage amount is your actual damage, your loss is your 50 rupees. So this is the 50 rupees we are saying about, we are discussing about ordinary damages. Okay. But when we are saying about special damages, say Kishan has told that I have to, no, suppose you have a special contract wherein you have, Kishan has told you that this has to be for a government uh, contract wherein I will be getting a 180 rupees, and if you will not delivered me, then in that case the rest amount has to be recovered from you, and you have not informed that at the time to the vendor from whom you are purchasing at 100 rupees, right? So this is the special information which you own but not the vendor from whom you are purchasing. So the ordinary loss here will be again 50 rupees. But if the vendor from whom you are purchasing at 100 rupees, if he has this special information, and if you are and he is aware that you have to pay the 30 rupees of extra loss if you will not no deliver on 26th to Kishan, then that time you can also recover that special damages from the vendor because he has the information at the time of entering the contract. Is it clear?
Yes, ma'am.
Yes, ma'am.
So special damages is not always available. It is depending upon the information which the person is owning. Section 23 you have to read. This is what just immediately we have discussed. And important thing, any kind of indirect or no any kind of indirect loss is not to be recovered from the party. So the vendor is not required to pay any kind of indirect loss happened to you. This is the example which you can read. Okay, सबने पढ़ लिया ना?
Yes, ma'am.
Okay. For special damages. आप लोग पढ़ लीजिए. We have discussed already. In case of in this example, tell me whether that person is able to recover the special damage or not. Whether B is liable to pay any kind of special damage.
No, ma'am.
Why? Kishan, you have to give me reasoning for that. Ananya, what circumstances it is mentioned? Here A has delivered a machine to B to be delivered to mill. A also informed B that his mill work was stopped for want of machine. Hey, A has only informed about that his mill work will be stopped if the machine will not be delivered, right? B unreasonably delayed delivery, and in consequence, A lost government contract. Whether B is aware about the government contract?
No, ma'am. Sorry.
Yes. So B is not aware about the government contract. He is only aware about that. Okay, if the machine is not delivered, then the work at mill will be stopped. So he will be only responsible for the ordinary loss which the mill would have in ordinary situation incurred. Okay, but not for any consequences happen because of loss of government contract, because this information was not there with B.
Ma'am,
Yes,
the
ma'am.
consequence is too remote.
Yes, consequence is too remote because he's not aware. That's why, I mean, if that information is I mean, he might have the government contract, he might not be having a government contract, he is not having that information. But if he has information, then he has to, because this is a special information which he owned. Vindictive or exemplary damages, it is only awarded in two cases. One is your breach of promise to marry, because it causes injury to the feelings. Okay. Second is for wrongful dishonor by a banker of his customer's check. What exactly the suppose if the banker, the customer has sufficient money in his bank account, and he and the banker by mistake dishonored the check. In that case, what loss the customer will have? His reputation, right?
Goodwill.
Yes, goodwill. Its reputation will be is going to be impact, and for that reason, a vindictive or exemplary damage is to be given to a customer. Nominal damages, when he has not suffered real damage. So as we have discussed that, uh, the court is saying that okay, there is no, you are, one person is winning person and another person is, so in that case, in order to ensure that that will be considered as then awarded just to establish the right to decree. So in many of the cases you have seen that rupees 1 has been given, so there is no actual damages happened. In tort law, you have you might have come across many of such example, like there is a damage but no injury. Damages for deterioration caused by delay. Deterioration not only means physical damages to the goods, but also mean loss of special opportunity of sale. These damages can be obtained even without notice. So in that case, like the earlier case which we have which we have discussed about the meal, suppose the other person has not delivered the no machine on a particular date which he has to deliver, and he has done some unreasonable delay, then whatever the loss he would have, no, because of that machine unavailability that mill owner has incurred, that amount, that will be an opportunity, right? He would have used that machine for producing certain product which has to be sold, but however that person has not able to do that, and there is an opportunity of sell, that is considered as a loss, the ordinary loss, and it is not required to be on notice, that that there the B is not required to have a notice about this. It is an ordinary business scenario wherein everybody is aware that if that machine is not delivered, then the person meal owner will incur this much of loss because of unavailability of that machine. So for incurring for paying that damages, prior notice is not to be required. Okay, prefix damages. So, have you came across any term like liquidated damages penalty or you have seen in the contract people are mentioning that okay, if you will not perform this duty, then you will be liable for 10 lakhs rupees. So whatever
Yes, ma'am.
amount has been mentioned, yes, whatever amount has been mentioned in the contract, that will be considered as prefix. Like at the time of entering the contract, you are saying that ki, okay, if that performance will be not done, then this amount of money I will be recovering from you. So you are prefixing that amount, that damages. At that time you are might not having that damage, or might not be might be no because of say any of the scenarios happened wherein such damage has not happened to you in the real world scenario. Then in that case, what about the prefixed amount? Will you be able to recover that amount because it is there in the contract? So there is a two terminology here. One is called as liquidated damages, and the other is called as penalty. Okay, so even if if even if in the contract it is mentioned as a liquidated damages is your 10 lakh rupees, but on that date when the actual when the actual damage happened, that is uh, only you have a loss of rupees 2 lakhs. So will you able to recover that 10 lakhs rupees saying that it is mentioned as a liquidated damages? No. You can only recover that much amount which you have actually incurred it, and not the entire amount which is mentioned in the contract. So whatever the terminology in the contract is mentioned, it is not important. It has to be seen the nature and the actual loss. So if the damage is equal to loss, then it is called as liquidated damages. And if the amount is mentioned which is more than the actual loss, then the additional amount which is mentioned will be considered as a penalty. Okay, so in case of your English law, we can there is this differentiation is given: liquidated damages and penalty. But in the English law also, liquidated damages are only enforceable and not the penalties. But Indian law is not about is not considered about this any of this terminology. They don't differentiate what is liquidated damages or what is penalty. They don't differentiate all this terminology. But they also only pay. The court will only award that amount which you have actually incurred, and not anything which is not you have incurred. Okay, so court is not bothered about the terminology. Court is only seeing that reasonable compensation to be given, which should not be exceeding the sum. First of all, suppose if you have mentioned 10 lakh rupees there, and you have incurred no 15 lakh rupees, so court will only grant you 10 lakh rupees because you have prefixed that prefix amount will be considered as a cap. So court will only pay you 10 lakh rupees. But if you have incurred only 2 lakh rupees, then court will pay you 2 lakhs rupees, not the I mean to say here the court will pay means court will enforce that payment amount no, that compensation amount. So you will get a decree of only 2 lakhs rupees and not the entire 10 lakhs rupees. Okay, but if you have incurred 15 lakh rupees, then the prefixing that damages in your contract makes you no, give you a capping here, and you will not able to recover more than 10 lakhs rupees. Is it clear?
Yes, ma'am.
See, what is the difference between liquidated damages versus penalty? So if you will see that by nature of the contract itself, it is visible that you will going to incur only 5 rupees of loss, but you are mentioning 10 lakhs rupees. Obviously it is very large amount, and this will consider as a penalty. It is visible. Genuine pre-estimate is a liquidated damages. When we are saying that whatever the uh, when we are estimating that, in case of our rice example, we are aware that 50 rupees that kitchen you are no, you have to pay that you have to sell at 150 rupees. Then in that case, you are aware that if it is not delivered on 25th, then uh, your loss is going to be 50 rupees. So pre-estimating any kind of genuine pre-estimate amount is called as liquidated damages. Okay, English law make distinction, whereas Indian law is not bothered about it. In India, court don't bother about distinction and award the sum so fixed in the contract if it is reasonable, however, not exceeding the sum so fixed. Okay, restriction of contract we have read. Okay, suit for specific performance. This is entirely will be discussed in Specific Performance Act. Suit for injection. Okay, again, wait, we have missed this one. Prefix damages. Here in this case, there is an exception, wherein even if the amount is not reasonable, but if you have entered an agreement, if you have entered into a no enter into a contract with a central or state government, where the performance is something which is no impacting public duty, or it is where the public are interested, then in that case, if you are breaching, then in that case you have to pay that amount even if it is a penalty amount. But all the contract which you are entering with the state government or central government, that doesn't mean that the public are interested into that contract. So the penalty amount will be there when only when the performance of any public duty or act in which public are interested. This is the key uh, concept. Okay, so when you are entering with the central or state government any contract, and if it is something which is of such nature that wherein public are interested, then only the penalty amount has to be paid, whichever whatever amount is mentioned in the contract. But wherein the public are not interested, then you are not liable to. Then the concept of liquidated damages will come. Okay, so suit for specific performance, suit for injunction. So there are three kind of. One is your temporary, permanent, mandatory. This will also be again discussed in your Specific Performance Act. Quantum merit, it is like suppose one person has performed certain part of task, and the other then in that case the other who has received that from the person, he has to pay that amount which he has recovered. Like, it is no unjust enrichment should be done, right? So if suppose if some person suppose Mr. A has said given a service for 5 days, but has not given but he is required to give for 7 days, then that Mr. A is allowed to recover amount for 5 days, but not for the rest of the 2 days. Okay. However,
Yes,
for the
ma'am.
but for the yes. So the for 2 days which should come, he has not given the service. Then for that 2 days, the person who is in the receiving end of the service can recover, can claim for damages. Okay. Any question? No question. All the concepts are very crystal clear. Shall we end the class? Thank you, Ananya. Thank you, Kishan. Okay, let's end our class. And if you all also want certain question, okay, like if I will give you certain task wherein you have to write the answer, and if you want to submit those answers to me, then please tell me. Then accordingly, I will give every day one question to you all, which you can write and submit to me. Are you willing to do this exercise, or you all are overloaded? Or you stop preparation because of no, there is a confusion about 3 year practice rule and all those things? I suggest that do your duty. Yes, I have lot of responses that wherein you have asked for me the questions. I will give you from tomorrow. Okay, I'll tomorrow itself I will give you the question and my email ID. Okay, Ananya. So every day I will give you one question, and therein you can submit your answers to me over email, and I will check and give my opinion over that. Okay. Bye. Bye, all. Good night. See you tomorrow.
Good night, ma'am.
Thank you all.